Hi, everyone. Welcome to a very interesting panel, if I can say the least here. With the grey skies today, we are dealing with a law which has primarily been in the grey right now until the July 5th, where the cabinet has passed the bill, and hopefully in the monsoon, as the government has stated, it will become a law for all of us to ponder on in the digital age in terms of data. Because up till July 4th, I think data is the new oil was what we were touting for. But after July 5th, we have to go for data can get you a penalty up to INR 250 crores. So from that, I'll, before opening the floor, I'll just quickly, for everybody here, give a quick introduction about myself, and I'll leave the introduction for the panelists for them when they give in their comments. BW has stressed that we wrap up the panel earlier than we were supposed to, so we'll try to accommodate that as well. I'll just quickly take a minute to give an overview of the Digital Personal Data Protection Bill before we involve everybody in the discussion, just as to highlight the main features for everybody to be on the same page. As we know, the mother legislation is the European Union, which we now know as the GDPR Act, and how a lot of inspiration has been drawn from there. And in terms of the scheme of the Act, we have major inclusions and terminologies, if I can say so, like the data fiduciary, which are basically your companies which are collecting data. In this case, your data principal, which is your consumers, the customers, us in a lot of cases, and then the data processors where the data is stored. And then we, in terms of implications, it has implications both on the online, offline, and with the brush of the extraterritorial jurisdiction as well. And in terms of authorities, what is being created here are grievance officers, your data protection officers, and your data auditors. The last two being majorly for the significant data fiduciaries, which we'll discuss during the discussion on our panel today. There's also the concept of a consent manager, and there's stress on vernacular languages in line with the 8th schedule of the Constitution. And interestingly, there's a concept of the artificial jurist person, which will draw a lot of interest in terms of the avatars that we have in today's day and age and how we'll play around it. Then we'll have the compliance framework, which we'll delve deeper into in terms of the constitution of the Data Protection Board of India. And of course, the penalties that we've already spoken about. So from here, I'll switch on to Mr. Amar Sundram to take us through a very important backbone of this act, which is consent. And consent is kind of very important for this in terms of being a very solid backbone for the act. And I'll leave it to you from here.
Thank you, Shivaarti. First and foremost, and I'm sure Sachin will agree with me, we are feeling so empowered with a panel of female colleagues with us, 4 of them very knowledgeable co-panelists. So thank you so much for this question. So this bill has now been approved by the cabinet, and the format and the form in which it has been approved is not in public domain. And therefore, we will talk about whatever is in public domain, which was prior to the approval by the cabinet. We understand that there could be some minor changes here and there, but by and large, whatever was originally drafted is what we are going to discuss. Consent definitely is the backbone of this entire digital personal data protection bill. And without consent, this bill will lose its importance and significance. When we talk about consent, there are a number of very unambiguous provisions in the bill which talks about giving of a notice, and it says that the notice should be specific, notice should be unambiguous, notice should be clear, and then the notice has to be given by the data fiduciary to data principals, which are the data subjects. Uh, when we talk of consent, there are other provisions in the bill which also talks about the obligations and the onus is on data fiduciary to prove that the notice was given and the consent was obtained from the data principals. So every organization, as and when this becomes an act, will be required to give notice seeking consent from the data principals, which are the data subjects. Data which has already been collected, right, before this becomes the act, even in such cases, it is required that a specific notice is required to be given. So that is a very, very critical aspect. A running organization, they might have collected the data, but the fact that this act has come into force, whenever it comes, then you are required to give another notice and seek those consent where the purpose is defined, and you have to be very, very specific for what purpose you are collecting these data. So there is a requirement for itemized details which should be given in the notice. What the bill also says that this notice could also be clubbed with any other document. So they have given an example of the bank KYC documents. So this can be clubbed with any other documents where this notice can be given. But the thrust is that the notice has to be given, which is very specific. Consent has to be obtained, which should be voluntarily, and in a very, very clear terms that the consent has been obtained and the onus is on it. Now, there is also a provision of a deemed consent, right? So, which is a very, very important aspect, and especially it's very good for organizations because there are certain areas where you can't go back to the employees and talk about consent each and every time. So, in addition to the voluntarily giving of the consent, a lot of data principals are required to give voluntary consent. When you are booking a table in a restaurant, and that's the example which is given, you give your mobile numbers, you give your names. So those are data which you are giving voluntarily. If it is given voluntarily, it is considered as a deemed consent. For organizations, such a deemed consent would also imply that consent which has been given or obtained for the purpose of attendance, termination, employment related issues, you don't need to obtain a specific consent. There are consents which will be considered as a deemed consent. The provision also talks about withdrawal of consent. So a data principal who gives the consent can also withdraw his consent, but then he will be responsible for the consequences which happens because of such withdrawal. So that's the overall ambit on different facets of consent which is there in the bill. When I was looking at the bill from my organizational perspective, I thought that the deemed consent provision which is related to the organization is very, very helpful to the organization, where I don't have to go and collect the data every time. So maybe one notice is good enough where the consent can be obtained.
Thank you. I'd like to add here, in view of the high penalties that have been mentioned in this act, we'd just like to cover the fact that all the panelists here are speaking in their personal capacity, and their comments are totally to be taken in their personal capacity. So moving on, Damini, I'd like to, have your views on, of course, add to the consent aspect. And of course, what is there for in terms of children under Section 10? And if you could just guide us through that. Yeah.
Thank you. I think the data, the bill essentially is looking at ways in which you can get informed consent from everybody. So the whole philosophy is how to make consent simple so that it's understood by everybody who's looking at, in today's digital age, a mobile application or the web page or whatever. So it has to be really simple, easy to understand. You need to know the purpose for which your data is being collected. You need to know where your data is going to be used, how it's going to be used. So I think from a purposes standpoint, it's really empowering a data principal or the individual who's actually providing their data. I think there are some interesting nuances around how you will get consent when you're giving data on behalf of somebody else, which is also sort of permitted in the bill. There are concepts of deemed consent. For example, if there is a patient admitted to a hospital and you're giving the patient's data, how do you subsequently take, data from that patient? Or if you're using one of these services to order goods and delivering it at another address, and there is enough personally identifiable data at that address, I think how will we subsequently get consent? I think some of those questions will have to be answered, and we'll have to see how the industry sort of responds to that. The interesting thing with respect to children, which is your second point, is that in India we've taken the consent age to be 18, whereas globally the age is 13, and some jurisdictions it's much younger. So when it comes to children, you actually have to get verifiable consent from parents or guardians. So I think one is, of course, every time somebody signs on to your platform again, how you will look at verifiable content, how you will look at identifying whether someone's actually a parent or a guardian. I think those are things one will have to keep in mind going forward. And secondly, for children who are already on social media or, on digital platforms, how does one look at consent for those children, including deletion of data or modification of data for children? Even there, you would actually need consent of parents or guardians. So the Act, I think the purpose of the Act is really to protect, in a number of ways, individual data, its usage purpose. It even has provisions of, deleting data once the purpose that the data was sought is actually served. So I think all of this will now become central to business conversations once the Act is in force, as to how businesses drive this to make sure that there is compliance. Luckily, we have precedent with GDPR and a lot of the other global jurisdictions, the Singapore law, etc. But I think these would be interesting to see how this works out in India.
Thanks, Damini. Mr. Kalra, I'd like to rope you in, since we've spoken about the Data Protection Board of India, wherein all the consent and withdrawals and the right to forget, etc., which we'll be further discussing with Priyanka and Deeksha. So, in terms of it being heard by the regulator, which is the Data Protection Board of India, your thoughts on, of course, the constitution of the board has been very interesting and obvious to a lot of people, but your thoughts on that, please.
Thanks. And we agree with Amar on this, that we empowered with the women here. That's good to us also, and great to also all the persons sitting around us. So getting into the point which we're talking about on a data protection law, I'll come to the question of you later on. 2-3 points which I wanted to highlight when I talk about this bill also. First, on consent and all those things, transferring to third party, then a privacy by design is missing in this particular act, which is to be known into, which we personally feel should be there. Apart from that, on a child side, rightly said, 60% of children have their own Facebook account or social media account today. How to get this in, which itself says on a law that when can you be basically an app social media person to be an app, basically it says what it should be age of 18 always, it says itself. So that's a question to everyone, that how this entire law is going to build up on the child side, and how this guardian's permissions or acceptance should come forward when 60% of people less than the age of 18 are using the social media platform today, be it anyone. Coming to the questions of the moderator here, or we can say what name said something like that, a chairperson right now, sorry. So on a data protection, basically a board which is to be formed by a government of India. So what it itself says on a section 23 functionality, it says independent board, but there is no independent, which I personally feel. This board is to be appointed by government of India with the chairperson and X number of employees or members, which needs to be there, which is the main funda on this. When this board is there, the all functioning, withdrawal, strengthening is to be designed by the government of India. So where is the independence? That's a question which is going to come up in future and is going to be very challenging altogether. Plus, this board is empowered as a civil court, which is there, and with this civil court, they have also power to engage with the police to get some whatever they have. They have a power to summon to third party whenever they feel that there is a infringement or there is a requirement which is there. That's basically a structure which has been built in. And I personally, as my personal comment, I personally feel it's like an equipment like an ED which you're giving, and similarly a data protection board is going to build up, where there's a background is a government, but it's going to be front end by the board only. So it needs to be challenging situation for the businesses around, and let's see how it goes up and comes up in future.
Thanks. Priyanka, coming to you, if you could just, there have been, a decent, I'll not say a lot, but few judgments, because this is, of course, a novel area in terms of its jurisprudence. So I'd like, if you could just throw lights on few of the judgments that may or may not be directly affecting, because a lot of it has been under the ID Act, and this is a sort of a different realm. So if you could just. Yeah.
So September 2017, popularly known as Putta Swami judgment, and right now it is considered as right to privacy under Article 21. We had this judgment wherein the principles of privacy were laid down, right? And then in 2018, the Har judgment came, which has also laid down, the principles of the privacy and how it needs to be carried forward in terms of Aadhaar as well. So these two judgments, I think, are the landmark judgments right now in reference to the privacy. And going back to, I think, the right to privacy judgment, I think much needed at these times because it clearly laid down, as my co-panelists have suggested right now, that purpose limitation, consent, data minimalization, storage limitation, these are certain principles which need to be adhered to. Right now, we do not have a particular act which talks about the data protection, because we'll be having that soon. But I think these are the principles which need to be adhered to, which have been laid down in the right to privacy, which is intrinsic to our right to life under Article 21. Coming to Aadhaar judgment, I think the constitutional validity of Aadhaar was laid in the Aadhaar judgment. But again, the judges clearly pointed out in reference to the non-mandatorily ask for the Aadhaar. So there has to be limitation in terms of when you are seeking an identity document from a concerned individual, stating out clearly what is the purpose of seeking out that identity document. And it is mostly now limited to the services or the welfare schemes for which you can ask the same. Again, they reiterated the principles of privacy, they reiterated the principles of the storage limitation, ensuring that the data is federated in order to protect the privacy of an individual. So I'll wrap up with this.
Thanks. I'll move on to Deeksha. Deeksha, if you'd like to add to this and also to the realm of DPI in terms of the judgments or otherwise, leave it to you.
So I think DPI in general, or India Stack, it's a core focus for the Indian government, and it's actually being seen as a product that we are going to export outside, a very important part of G20. But for the GCs, where India Stack becomes important is the scope of public-private partnership. It's the government creating the layers of APIs that can then be used by the private sector, and that's the intention. So we are going to see, and with UPI, we have seen this. We have seen a lot of private players rush into the area, and I think the promise that UPI has given is extremely precious, and ONDC seems to be carrying that forward. So I think for people in this room, India Stack for the business and product teams is going to keep becoming increasingly important. And from the GC perspective, then there's a problem of regulatory compliance. I'm stepping into partnership with the government, but it's not like the government is treating me as a favored child. We've again seen it with UPI. We've seen it with other government partnership projects. It still remains extremely important for companies to recognize and identify the regulatory compliances. And the problem is almost everybody has identified is the law is very fragmented at this point of time. Of course, Aadhaar judgment in Putta Swami has laid down some foundational principles. Aadhaar becomes more important because it's very primary leg of the India stack. But what remains to be seen is how is all of this going to be put into law? And we've seen DPDP, that's one segment of it. But the other important segment is cybersecurity. Because data privacy is one part. India Stack, for it to be successful, cybersecurity will have to be equally looked into. And I think for that, we will have to wait and see how the DIA evolves. Digital India Act needs to address these things more strongly. We only have very soft laws, so we have the certain guidance. There was a lot of, even with our clients, there was a lot of confusion for around a year that do we have to follow these? What is the framework? it seemed very burdensome. And now we know that companies have received notices about why they are not compliant with the certain regulations. So I think that lack of clarity becomes a big problem from a GC perspective. How much cost to put in to bring your company into compliance when most of these are coming out as soft laws? And the focus, just looking at the time, I think to wrap it up, the focus should be now on solidifying these principles so that all of us on this panel have clarity on what to do and how important it is for things to be done.
Thanks. Mr. Sundram, just to wrap the panel up towards wrap, if I can say so. I'd just like to have your views on highlighting the gaps in in improving the bill as it stands. Obviously, we do not have the binary copy at hand right now, but if you could just share your thoughts on that.
First and foremost, it's a very good bill. My quick reaction when I see the bill, it's very simple. It's less complicated than what it was in the earlier version. Very simple bill, easy to understand. Now, having said that, there are a number of areas which will cause a lot of challenges going forward. One is the very definition of personal data. If you see, it's so wide. If you see SPDI rules, at least there are certain parameters which defines what is a sensitive personal information or a sensitive personal data. Now, current definition is pretty wide. So everything which goes on to identify an individual becomes a personal data. So very, very wide definition. Second is, and which is an area of a big criticism, is the overreaching power of the government. The huge overreaching power, and a lot of the people across the border which I have spoken, they're very concerned about the overreach. When it comes to state instrumentalities for a defined purpose, which is there, they can just bypass many. So chapter 2 gets bypassed, chapter 3 gets bypassed. No notice of consent is required. Consent is not required to be obtained. So wide reach of the powers. The only consolation is that at least if they are retaining the data for a period which is not defined, at least they still have to protect that data, and the safety measures has to be complied with. So that is one exception within the exception which they still have to maintain that. But overall, the reach is pretty wide. What they have not defined so far, and we expect that it may come up in the rules, is for which countries India can share these personal data. That is not defined today. They said that the government will decide. So today we do not know under what circumstances and to which countries these data can be transferred. Data board, again, while it says that it is an independent board, but the power to regulate, the power to appoint these officers rests with the government. How much independence it will carry, we don't know. So those are a couple of areas. I mean, the board also has the power to review its own order. I mean, that was quite surprising to me that they can review its own order, they can modify its own order, and the first appeal will go to the High Court. So these are a couple of gaps, but as I always believe that this is at a stage of evolution. The first thing first, the law should come, the act should be enacted, and as we evolve, we will have more and more clarity.
Thank you. If there's anybody from the panel who would like to add on the improvements they feel, please. Yeah.
I actually think that the government has listened to us, to the industry, and to a lot of people.
You're saying
while
that
revising
take it
this
into
bill, right? I actually think if you look at the first iteration of the bill, where there was criminal liability, there were there were various provisions which were actually fairly onerous. It's actually come down to sort of personal information. So I actually think that somewhere through this consultative process, I think they've done a good job at trying to listen to various stakeholders, and of course, the industry stakeholders and other stakeholders as well, individual stakeholders. So if you look at 90 sections down to I think 30, if I'm not wrong, they have simplified the bill at sort of various places, reduced sort of criminal liability, reduced other kinds of I think very burdensome obligations on the industry. So let's see how this plays out. But and I think there are also enough examples of like the CCI, of sort of organizations that actually function fairly independently once appointed. So I'm actually maybe a little more optimistic that this will function in a truly independent sort of manner. At the end of the day, also any decision that's passed is subject to challenge before a high court. So, slightly different view.
Thanks,
Just
Damini.
to add, Shivaarti,
Sure,
I'll
sir.
take 30 seconds to add. Let's see it from an Indian context, and let's see, analyze the bill from an Indian context. The kind of demographic population that we have. Now, this bill is going to touch, when you see the definition of data fiduciary, it will touch not only large corporate, it will touch SMEs, small scale industries, a small setup, right?
Any data fiduciary for
Any
that
data
matter.
fiduciary who collects the data, right? Now, see the quantum of penalty that is imposed. It's too huge, right? What and under what circumstances these penalties will be levied has been left quite open. So there is a subjectivity attached to the levy of penalties. Now, to begin with, my sense was that they could have made some more tables and some granular details whereby little less penalty could have been imposed for some of these less large scale organizations, because everybody will come within the purview of the act the moment there is a breach, be it a large organization or be it a small setup. And therefore, from a purely India demographic perspective, I see this is a big challenge, because any law's success depends on its implementation. If they are not able to implement or execute the law, the provisions under it, it will be very, very difficult to sustain that law. So that's another area of challenge in my opinion.
Sure. Thank you.
Just a few final words. I agree with Sir. I think the biggest problem with the Act right now is the cross-border data restrictions. That could actually, for a lot of companies, lead to an immediate stop on being able to carry out their business activities. Unless on day zero, when the law comes into force, we've already entered into an agreement with at least some of the major economies where a lot of data transfer is happening. So that is an aspect that needs to be practically thought out. And other than that, yes, a very nice short act, but one wonders if too much has been left to regulations then. So I'm guessing there'll be another process of coming out with those regulations, which might be good because regulations allow a lot of room again for consultative processes to take place. So we may have a more broken down consultative process for each of those regulations. And I think data localization was something talked about, removed. Now there's another speculation of it making a backway entry to the Digital India Act. So those will be probably some aspects still to be set into place before we actually know where we are landing on the privacy and cyber security aspects.
Just to add on.
Yes, sir.
Rightly said, penalty has been levied reasonably. What will be the penalty? No one knows. It's up to the limit. There's a liberty of data protection board to levy a penalty. There is a penalty section for the complainant also. If complainant files a false, fabricated, or impersonated complaint, it says they can issue a warning, and then a complainant can also be charged with a penalty. But penalty is not defined. That's a question basically which is going to come on rules. But rules again can't be beyond the regulation is there. That's the issue which is there. It should have been more detailed so that it could have been captured in rules also. That's it. Thank you.
Thank you, everyone. Just to close the panel, in terms of the techno-legal compliances of the current almost act, we've come across a lot of our clients who are already moving towards this, because data fiduciary basically is every company that is collecting data in terms of irrespective of the kind of its incorporation to begin with. And, it's what I'd like to add here is there are very interesting concepts that have been introduced, which by design will have implicit or direct effect in terms of its being a very quick process, that how this has been drafted, and in terms of it leading to the board and the board deciding in a lot of way how data should be treated or whether it is being treated rightly or not. So a lot of compliance is here, a lot of legal angles are here in terms of whether you've taken the right steps in terms of the architecture, IT architecture of your company, the softwares, the concept of the consent manager in terms of an admin platform. And what really caught my attention, and we've been advising a lot of our clients also on that front, is the techno-legal compliance that needs to be taken care, and how this board is told to be digital by design, which will be very interesting to see a lot of proceedings happening online. Hopefully. And in terms of a very interesting concept being the artificial juris person, which has taken into the bandwidth of even virtual influencers to begin with. And those are, I think, we are into very interesting times in terms of judgments, the kind of law that this is shaping out to be and how we'll see it delve in, since, the major audience here is constituting of data fiduciaries, if I can say so. So I think I hope it added enough value to your panel, because we're running short of time and there's a time's up blinking in front of me. So we are happy to take all questions offline, and in case anybody has any queries, happy to address that. Thank you, everyone. Yeah.